back into this common mistakes, and then we'll go back to questions that come in, please. All right. So going back to the common mistakes, the number one, and these aren't in any real order. These are just things that I have seen people do, right, and mess up on. Never serve as your own trustee. Why? Because if you are both the trustee and the beneficiary, the title can be merged back into your name as the grantor. And that kind of defeats the purpose of doing that. So you always want to make sure that you are not the trustee if it's your house, but the beneficiary. You put a third party in there as a beneficiary. Period. Now, who do I use for my stuff? I use my attorneys. Sometime back, oh man, this had to be about 8 years ago, the attorney that I was using retired. So people were like, oh my God, what are we gonna do? The people that were also using him, that we brought over there. It's a very simple thing. You just assign the trustee, the trusteeship as the grantor. You can do that. The trustee can actually do it, can name his successor. The trustee can name their successor. It's not a big deal. It's literally one more piece of paper and you're just naming the successor okay? So simple situation. But don't do it. Don't put yourself in that situation. Because there's a bunch of little catches that lenders can catch you on if you allow yourself to be caught, all right? Number 2, do not use your home address on tax statements. Why? Trusts are for anonymity. I can't say it enough. Trusts are for anonymity. Anonymity means no one knows it's you. You don't want them to know it's you, okay? So do not use your home address for tax statements as it relates to your trust, okay? This completely defeats the purpose, completely defeats the purpose. Now, what can you use? If you have a business address, use that. If you have a P.O. box, use that. But do not use your home address. Don't do it, okay? There's too many different ways that can come back to bite you in the buttocks later on. Number 3, failure to assign beneficiary interest. Why is that important? Why would that be? Because if the trust is sued, you will be liable. Who wants to be liable for a lawsuit? Not me, not you. So you have to transfer that into another entity. Even if you're using this for asset protection and it's just you and your family, you're gonna name someone else as the beneficiary. We only put it on the initial documents when we're doing sub-2 deals because we need it to be that way in the event that a lender needs to see it. In some cases, you'll have attorneys tell you things like, well, you can't put them on there because it's not an arm's length transaction. Well, it's not supposed to be an arm's length transaction, okay? It's not supposed to be. And they'll say they can't write the policy if it is. But there's a lot of different ways for you to circumvent that. That is literally just 1, maybe 3 sheets of paper, all right? 2 signatures though. And that's that. You just have to know what to do. It's not a problem that is insurmountable. It's something that you can have handled in a couple of hours, depending on where the people are that need to sign. All right. Number 4, informing your lender. As I said before, do not tell them. Why? Because even though the lender can't accelerate the note, because the due on sale clause, they can't just accelerate the note because of the Garment-St. Germain Act that I talked to you about. It is possible that they can assess a transfer fee though. So there's not a ton of lenders that are doing this, but I would imagine that there will be more and more that are going to add this in to their loan documents. But the ones that are currently doing it, they're charging it up to a 1% transfer fee. So the ones that I've seen, and I've only seen a couple. Well, one of them was 0.5% and one was a full percentage point. And that's of whatever the loan balance is. So if you're doing a sub-2 and you're transferring, or you're just transferring a property because you want to protect yourself, if the lender wrote it into their agreement that they can charge a transfer fee, if you owe $200,000 and you at the time of transfer, they see that transfer on that time, they know what it is, they can charge you 1%, $2,000. That's what they're going to charge you, or up to 1%. Let me say it that way. So you want to be cautious of stuff like that because when I say cautious in this case, you just want to know. You want to know. And reading those documents is going to help you know. Talking to the lender is going to help you know. You can avoid it, and the only thing they can do is send you a bill. So even if you don't read it and you don't know, all they can do is send you a bill. And that's the worst that's going to happen. Number 5, referring to the trust as a land trust. Why? Call it a grantor trust. It's accepted in all 50 states. Now, if you're doing a ton of deals, then yeah, I would tell you to just call it a grantor trust instead of a land trust. And those have everything to do with the 2 states that I just mentioned, okay? It's really just those 2 states. I am currently unaware of any bills or anything in any municipality that have to do with asset protection laws being changed in this manner, okay? So unless you're doing a ton of them and you're working in some of those places, utilizing it as a land trust or calling it a land trust is just fine. But if you want to, err on the side of caution, you can call it a grantor trust, because again, land trust, grantor trust are accepted in all 50 states. It's just what you're going to call it. And there's only 2 states where it'll be structured a little bit different. That's just, again, let me say, I am not a lawyer. I have just spent, I started doing trust in 2004. So for 19 years, I've been chasing around attorneys, learning, being out here in these streets, making deals, making things happen from state to state. From state to state. I'm not talking to you about just what I do here in Georgia. We do it here. We do it in Alabama. We do it in Texas. We do it in Arizona. We do it in California. We do it in Florida. We do it in Carolina. We do it everywhere. So it's imperative that, you can hear me, and I'm appreciating everybody that's here listening and asking questions right now. But I got to tell you, the information that I have is great. It's usable. We're using it all the time. But go to an attorney. Talk to your attorneys. They're going to charge you up the wazoo, but that's okay. That's okay. I can't tell you how many thousands and thousands and thousands of dollars I've spent on these contracts, the whole contract package, that over the years, modifying them, bringing them up to date every so often. When the law changes, we're changing them, or if we want to do something different, or if we've recognized some kind of acknowledgement we need to add or subtract, we make it happen 100% of the time. We have to deal with attorneys to do it because we want the legal jargon to be there the way it should be, right? Because all those ifs, ands, and buts and twos matter if they're not in the right place. I want to make sure they're in the right place. And I want to have a level of protection. If somebody makes a mistake, it's going to be them. I don't even know how much money we've spent on these contracts over the year. I have no idea anymore. It's definitely 5 figures though. Definitely 5 figures. All right, so we have a question here. Get to it. Star, what's going on? Great information. Glad I've subscribed. Don't forget to subscribe and like, people. Please do. Please do. And thanks for the PSA. I appreciate the PSA, Star. I need that. Thank you very much. I'm giving you everything you need to find success as a real estate investor. So make sure that you subscribe to this channel and like this video. See you later.